The Supreme Court interpretation of the Second Amendment is extreme, it's radical, and it's wildly incorrect. It just isn't supported by the text of the Second Amendment. It's not supported by the historical record. And it's also just inconsistent with the way the Supreme Court historically has interpreted constitutional rights. The text of the Second Amendment, hopefully I'll get it right, it is a well-regulated militia being necessary for the security of a free state. The right of the people to keep and bear arms shall not be infringed. And there's the militia clause, well-regulated militia being necessary for the security of a free state. And then there's the other clause, the right of the people to keep and bear arms shall not be infringed. The way the courts interpreted the Second Amendment for 220 years is that those two halves relate to each other. And that the Second Amendment essentially means because a well-regulated state militia is necessary for the security of a free state, the right of the people to keep and bear arms to participate in that well-regulated militia shall not be infringed. Makes total sense, and that's what James Madison and the other framers meant when they wrote it. The current way that the Supreme Court reads the Second Amendment is either, sort of eliminating that first half, or else if you want to sort of try to force it into the text, it reads something like, because a well-regulated militia is necessary for the security of a free state, the right of people, including people who have absolutely nothing to do with militias and may be opposed to militias, may be opposed to a free state, can have guns to use in private self-defense. I mean, that isn't logical, and it isn't what the framers meant. In fact, James Madison and the other framers saw other proposals that some states were making back in the time when the Second Amendment was being considered that had language about, there should be a right to have guns for hunting. There should be a right for people to have guns in defense of themselves. That was language they knew about. It was written and proposed by others. They rejected it for the Second Amendment. And that's not to say that, James Madison and framers thought that guns should be banned. No, but they just didn't intend to protect private gun rights in the Second Amendment. There are a lot of things that they thought shouldn't be banned. They didn't put them explicitly in the Constitution or the Bill of Rights.